Good morning. May it please the court. Kara Rockenbach on behalf of the appellants, Mr. and Mrs. Jervis. The question that this court has to decide today is whether, when the Florida legislature uses plain words, do they have meaning? When the Florida legislature says shall 16 times in a statute in one section and shall another 10 times in the subsection 9, do they mean it? And what this court has already said in Douglas is that, we're talking about the UM statute that this court has already addressed and looked at, is that these words absolutely have meaning and they cannot be rendered meaningless. This court looked at the UM statute 627.727 in the context of, just like what we have here, a Class 1 named insured in the Douglas decision. And now Justice Pariente, sitting for this court back in 1993, authored the Douglas decision and said, and it was in context identical to this case, subsection 9, the stacking of coverage, and this court said that GEICO, in that case and should be in this case, must satisfy two prongs. GEICO must satisfy the statutorily mandated requirements of notice to the insured, and the second prong, GEICO must obtain a knowing acceptance of that limited or lesser coverage. The Florida Supreme Court approved this court's decision and went further and actually quoted that quote from this court's decision and said the statute must not be rendered meaningless, and went further and said this statute, which is a very heavily regulated statutory aspect of insurance coverage, insurance law, it is a quid pro quo. The Florida Supreme Court 2 years ago, just 2 years ago, said that this statute is designed to protect who? The insureds. It's not designed to protect GEICO, which is why the statute says shall 16 times with regard to the...
Well, okay, let me ask a question first, because
Yes.
the dispute appears between what's required under 1 and what's required under Section 9 of this,
Correct.
as far as whether or not there has to be a written rejection. But both in 1 and in 9, the insurer shall inform the insured on a form approved by the Office of the Limitations
Absolutely.
Imposed. Let me ask you this question.
Yes.
Is there one form or two forms? Is there one form for 1 and one form for 2?
Great question, Your Honor. It's probably not something that the parties really briefed or discussed, but in this case, it was the MN form. And both questions were on this defective, non-compliant, in violation of Florida law form.
Okay, so you've got one form in this case
Right.
that was trying to do both written rejection
Right.
of uninsured motorist entirely and also
Stacking. Correct.
Okay, so we have one form.
Right, and what this court should recognize is that you have building blocks in front of you, multiple building blocks upon which you build a solid foundation for reversing this judgment and entering judgment in favor of Jervis. And Your Honor's questions go directly to the first two building blocks, which is there were two circuit court judges below, two different circuit court judges who found that MN form void. It was non-compliant with the requirements of the law.
How would you distinguish the Belmont case?
The Belmont case, thank you, Your Honor. So Belmont is not on point, and this is why. It involves the Class 2 insureds. That's a different path that we don't, and for purposes of our argument today, we first argue that this court should reverse the judgment, enter judgment in favor of Jervis, because you don't apply the Class 2 law as to a Class 1 insured. So Belmont talked about Class 2 and talked about, it was a daughter of the named insured involved in the Belmont versus Allstate case. And Allstate was then, they reversed the appellate court, I think it was the 50 CI, if I'm not mistaken, reversed the summary judgment that was in favor of Allstate and said Allstate can go back below and try to prove this oral knowing waiver. But we don't have a Class 2 insured in this case, and that is what Belmont involved. But the building blocks are these two, and they're really important.
Did Belmont involve a situation like this case where the insurance company effectively gave no notice because the notice in this case was declared void? Or was Belmont a case where the notice was, proper or not challenged, And the question was whether there could be an oral
Waiver
Waiver.
below, I have to look, Your Honor, I don't know the answer to that question. There are so many of these cases, and they all have factual nuances, but it's an important question, I recognize that. I will check my notes, because I think I have the answer in the brief. The building blocks are important because of these two summary judgment motions, and I have to point this out to the court, because they weren't cross-appealed. They weren't cross-appealed by Geico. Geico didn't even challenge them below with any evidence. In fact, Geico strategically told the trial judge at the time of trial, we're not going to present any evidence with regard to the electronic signature process. We're not going to give you any evidence because we don't want to open the door. So we're not going to talk about...
They gave no evidence that there was any notice given?
Correct. The notice that they talk about is all oral. They say, well, you knew that we had a conversation, Mr. Jervis, you're a very informed, intelligent man, you knew generally what UM was.
Okay, so they've taken this a step further than the other cases, and it's not just that you can have an oral rejection, but now it's an oral notice.
There's no notice they have not proven the two prongs, and that's really critical, because this court in Douglas said, and by the way, Douglas was all about subsection 9. It was 9D in play at Douglas, which is the stacking of UM. And Douglas is really clear and said there are two prongs. You have to prove that you have satisfied the notice part, the mandatory requirements of notice, and then you have to, prong 2 is the knowing acceptance of the limited coverage. It is odd the way the statute's written. The umbrella UM is that you reject UM, and then the stacking is that you accept the limited coverage. They're both less coverage, both of them in concept.
This whole case revolves around what Judge Warner started this with. One shall be in writing, and whether 9 has to be in writing too.
It does. Yeah,
Okay,
it does.
so-
It says
so
that.
that's-
It's clear in the statute that
Show me in 9 where it says that.
it starts off, it's a paragraph, and if you drop down under 9A,
Yeah.
there's a paragraph indented all the way to the far left. I think it's in connection with the offer authorized by this section, insurers shall inform the named insured on a form approved by the office, which is identical to 1. It's still this form that has to be approved. Why is this so important? Because it is public policy. This is a quid pro quo statute. We are allowing, the legislature says, we're going to let insurance companies sell less UM coverage, but by gosh, they better do it right and they better follow the law. So what happens is you have building blocks. You have the two summary judgment motions. They haven't been cross-appealed. They weren't even challenged below because they were afraid of opening the door to the UM statute. Didn't want the jury to hear about the UM statute. Didn't even want to delve into their defective, improper electronic.
How did you manage not to mention the statute? I don't understand that, because
I
we're
agree.
talking about statutory requirements.
Thank you. Your Honor, incredibly frustrating. I have trial lawyers sitting in this courtroom who I know are palpably relating to that question by the court, because it's incredibly frustrating when you get to the jury verdict. This verdict was rendered in a vacuum with no context. The jury didn't even know what they were deciding, whether Mr. Jervis had rejected or accepted. They didn't know the legal right that he had because they were never informed of the law. But that was so if we could just backtrack for a second, you have these building blocks, and we stop with the building blocks of two summary judgments that haven't been cross-appealed, that weren't challenged at the trial level with any evidence to support or try to rebut the finding that these waivers were void. Then you have your next building block of an undisputed record fact.
Let me just ask you this, just to make sure I understand.
Yes.
How can there, if the statute, which appears to be true, is mandatory that the notice,
Right.
the notice, not so much, the notice has to be in writing, how can there be, the second aspect under Douglas and, Quirk, which I think Judge Altenburn wrote.
Correct.
How can there be an informed and knowing acceptance of a non-stacked policy where there's been, the mandatory notice provision has been complied with? Isn't that the end of the story?
It should be. It really should be. Yes. That is what the insurance industry is getting. And so the requirement should be by law, but you have a body of cases that talk about Class 2 insureds, which is Quirk, which is Cabrera out of the 3rd DCA. And when you get to these Class 2 insureds, the courts judicially engraft this oral waiver. And I think the concept is, if you think about it in terms of Cabrera, it was a trucking company. So you've got an entity that has all of these thousands of drivers, right? So you can then use this oral waiver in that context. I mean, the oral waiver
I don't
doesn't
really, I mean, I have to admit, I don't understand what difference it makes whether someone is a Class 1 or Class 2
Class
insured.
2.
Class 2 insured is not, is somebody that had nothing to do with the policy.
Correct. It's like a
So-
third-party beneficiary of the policy. They're not a named insured. So it should be the end of the story. It should be. And that's what we believe this court should find and draw the line and say, just as Douglas did, this must be complied by. This is a benefit it's to protect the insured. And if you don't check the box and do the right form, then as a matter of law, the 3rd District Court of Appeal in Anakov, it's a case cited in the briefs, they said, by operation of law, if you don't comply with the statute in context of a named insured, then there is full UM coverage. You get UM coverage, you get stacked.
This concept of allowing an oral waiver of the under 1 is where we've most found it. Is kind of interesting, because when you trace it back, it just doesn't seem to, actually, it was one of our cases where they just said, well, we're going to let them do this.
Right.
Because it was, in that case, I think it was Del Prado, which is cited in one of the other cases, which I found it, was that it was because the named insured was saying, wait a minute, I didn't agree to this. So, and it was a Class 2 insured wanting it, and they said, well, we're going to let you show that even though we don't have the written form, the named insured really didn't agree to this.
Right.
So there wasn't a contest as there is now. But
And it might be, Your Honor, that Del Prado is pre-1982, 1984. It's really significant. Judge Gross mentioned the Quirk decision, and that court talks about it is really important for this court and all courts when looking at this statute to make sure you're on the right statute.
well, let me ask another question, just another thing. What was the evidence here that Mr. Jervis orally rejected or orally accepted this? Because, I mean, we have was it just the business practice saying, well, I have this business practice?
Yes.
And when I get to this point, then the only reason I would do this is because somebody, the client must have told me to check this box?
Okay, so now we have moved from the venue of we win as a matter of law. This gets reversed because oral waiver doesn't apply here. That is the primary threshold argument that Mr. and Mrs. Jervis present to this court and ask you to reverse on. If we go down the rabbit hole of applying oral waiver to Class 1 insureds, which we request this court not to do, it would not be what, it wasn't raised in Douglas. It wasn't referenced, it wasn't written about. But if you do that, then let's talk about what the evidence was. Thank you for that question. Mr. Jervis testified that he did not waive. He did not know. He did generally know about coverage. Yes, he is an intelligent man, informed businessman, and had rejected coverage in the past for an entirely different vehicle, a business vehicle that had an umbrella policy with State Farm. Completely different. This is apples and oranges. These were his personal vehicles with Geico. Why would he be held to having a knowing, informed waiver based on past conduct with a different carrier, with a different policy and different coverages?
So
it's
all
not,
of this, okay, but.
it
so-
doesn't
so
prove-
there is- I'm interested in, you're almost out of time, but the cases talk about oral waiver, but they never say how that's
you
done.
prove it,
I mean, it's
right.
one thing if you have the insured, the agent saying, I talked to him, I gave him the form,
I need to-
here it is.
Yeah.
He said, I don't want this, and
Didn't
that's why
happen.
it's done.
Didn't happen.
But when you're working strictly off of business practices, is
Right.
that sufficient to, well, that's
No,
something we'll
not
have
at
to
all,
think.
absolutely not. In fact, and so just, I need to tell you the rest of the record evidence in the trial testimony. Mr. Mercurio, the Geico agent, testified he couldn't remember the phone call. He couldn't remember, but his general business practice when he worked for Allstate, not even Geico, was to go through these coverage checklists, and he would have offered it. So when Jervis has tried to cross-examine and impeach the testimony of Geico's witnesses regarding Geico's general business practice, which was proffered, including a memo from Geico that the jury never heard about, where this memo says, if you don't follow this statute, if you don't get a written rejection, you get coverage. That was never presented to the jury. So if we're going to go down the rabbit hole of oral waiver, which we should never do with Mr. and Mrs. Jervis, Class 1 insureds, and if we're going to go down the tangent of looking at Mr. Jervis's general knowledge of and his past conduct with other carriers and other coverage, then we sure should have been able to talk about Geico's general business practice. It led to confusion in this verdict and other errors.
I just ask one more question.
Okay.
Yeah, just one more.
We'll let
Thank you.
Jervis.
I was
Please.
hoping to reserve some time. I
Yeah, I mean,
apologize. There's so much to talk about.
I forgot what it was. I'm sorry. No. Thank you.
Perhaps a rebuttal,
No, no,
but
here's-
there was a
here's-
Belmont question I know I need to answer for you.
Here's what it was. I
Talking.
actually found the answer to the Belmont question in
Okay.
footnote 1, so you don't need to look that up.
Okay.
But has this court ever expressly held that oral waiver applies here, or has it always been other districts?
Other districts. I did not see that the fourth, in candor to the court, the Douglas decision doesn't even say oral waiver. Geico must not have raised it. I have no idea because I didn't pull the briefs from 1993. But in the Douglas decision, it just really emphasizes how important compliance with the shall and how the insurance company has the obligation to check both of those two prongs, giving notice and obtaining the knowing acceptance of the lower coverage.
Thank you.
Thank you very much.
May it please the court, counsel. My name is Suzanne LeBrit, and it is my pleasure and privilege to represent Geico today. I'd like to start with the legal argument with regard to what the statute says and what it requires and why and for whose benefit. In subsection 9, what the statute says is that if an insured has decided to go with coverage as opposed to reject it outright, which is what subsection 1 covers, then the insurer is obligated to, to get a conclusive presumption that the insured accepted non-stacked coverage, the insurer is required to show the insured on a form approved by the state the limitations of that coverage. If the insured signs that form, the insurer gets a conclusive presumption. And Judge Altenburn, in the Quirk opinion, explained that, yes, generally the statute is designed, it's a statement of public policy by our legislature to protect insureds against an outgrowth of financial responsibility. But the specific provisions concerning the conclusive presumption, and I would like to read from Quirk, the purpose of the 1982 and 84 amendments that established the written notice requirements and the conclusive presumption is to benefit insurers by reducing litigation, which had historically arisen without the written notice and rejection requirements, as to whether uninsured had been purchased and if unstacked had been selected. So in that
Well,
thread,
in that sense, he's saying, look, we don't have to get into fights with the insured, because we're going to require this.
well,
So what you're trying to say is, well, the insurers cannot accept this and then they can litigate all they want?
Well, I think the law is that insurers, the statute says what it says. If you want the benefit of this conclusive presumption, you need to have a signed version of this.
Are you applying that to both the notice as well as the waiver of the provision? In other words, that you can orally notify them and that will satisfy Section 9?
Your Honor, that is what every case that has decided this issue has interpreted these statutes, and the trial court was bound by the holding of Belmont, which was exactly on point, and I want to correct something. Belmont did not involve Class 2 insureds. It involved Class 1 insureds. The Belmonts were named insureds. That's a Class 1. Family members, which was the Belmont's daughter, are also Class 1. And I would draw the court's attention to the Harrington opinion of the Florida Supreme Court that was decided in 2014, which makes plain, in no uncertain terms, that a Class 1 insured, this defense, can be raised against a Class 1 insured. Crystal Harrington, and the reply brief says otherwise, was not a Class 2 insured. She was a Class 1 insured.
But footnote 1 in Belmont, this is why I think that's distinguishable, is the court notes that the form the company used was the one recommended by the insurance commissioner. So that was a case involving, a valid notice initially. I mean, do you have, your brief cites the one case that I found, but, is there a case, or which case is the one that doesn't involve notice, a valid notice?
Cabrera is a case that there is a question as to, the form was destroyed, which is similar to this circumstance. The trial judge determined, as a matter of law.
But in Mohammed, too, in other words, Mohammed was another case that the third district decided.
And it's very short. It's not clear in Mohammed.
Well, there's no analysis as to what that's going
correct.
on. And in Cabrera, it looked like the third district was trying to backtrack and kind of, like limit. I don't know what they were doing with Mohammed, but it's not like Judge Schwartz gave a long analysis of why he wasn't allowing that, did he?
In Mohammed, no.
No.
In Cabrera, Judge Cope, who wrote the Cabrera opinion, reversed the decision for the insured because the trial judge gave an instruction very much like the one these insureds requested. Cabrera did not feature, if there was a form, it was not available and it wasn't introduced or referred to, and I don't think the opinion makes plain what the history of the form is. But I think what is important to understand here is the trial judge makes a determination as a matter of law whether the form complies with the requirements of the statute. And here the trial judge made that determination, that the form which was given and bore what we think was the electronic signature of Mr. Jervis didn't comply. At that point, the line of cases, Belmont for stacking versus non-stacking, Chmielowski, Quirk, and all the other cases that are cited in our briefs, which go to the propriety of proving an oral rejection or acceptance of rejection of UM altogether,
Right,
or acceptance of the limitations of stacked. Those cases are consistent, and they don't distinguish on the basis of Class 1 versus Class 2.
So,
in fact.
but your opinion then is that you can prove at a trial both oral notice and oral rejection.
That is correct, Your Honor. And I want to clarify. So our position is that as a matter of law, if you don't have the benefit of the conclusive presumption, the trial judge can, in all of these cases, confirm this, allow the insurer to attempt to prove an oral either rejection of UM altogether or an oral acceptance of the limitations.
Then what is the point of the statute?
The point of the statute is to eliminate most litigation it's to encourage insurers to get this paperwork signed so that they can have the conclusive presumption. That's exactly what Judge Altenburn opined in Quirk. But the body of law remains the same, and I would like to touch on what happened here after the trial judge determined that the form was not sufficient for purposes of establishing the conclusive presumption. He followed Belmont, Chmielowski, Quirk, and all the other cases that are cited in our brief, and allowed GEICO to proceed with proving the oral waiver. And I want to focus the court for a moment on the evidence that was proven. The first thing, and this is really important to understand, Mr. Jervis doesn't claim he didn't know what UM was, and he doesn't say he asked for UM and didn't get it. He testified very clearly, and I invite the court to look at the record on this. What he wanted and what he got was UM in limits equal to his BI limits, and that is at the transcript page 2081, lines 20 through 25. So there was no confusion on Mr. Jervis's part about what he wanted and what he got. The evidence that GEICO introduced was not just GEICO's business practices. GEICO introduced evidence from Mr. Jervis himself that he had historical knowledge regarding uninsured motorists, that he wanted and got matched and non-stacked UM from GEICO. That's exactly what he'd carried with State Farm for many years previously. GEICO introduced the archived application that was contemporaneously prepared over the phone, because in this day and age, how do we buy insurance? We do it on the phone. Mr. Mercurio prepared an application. It's Defense Exhibit 4. It was admitted over objection at trial transcript 1722. Jervis has not appealed that ruling. The contemporaneous application that Mercurio prepared provided step-by-step explanation. There's no question that Mercurio prepared it. It shows on the exhibit itself that he did, of how he completed it, and that it confirmed that Mr. Jervis selected non-stacked. That's part of the application. Mercurio's routine practice, which was consistent with Geico's practice, albeit Geico normally provides a sales pitch and then does coverage counseling. He preferred to use Allstate's methodology, which is to go straight to coverage counseling in connection with the sales pitch, not materially different. But that was his routine practice, and Mr. Jervis himself testified that if Mercurio had given the explanation that he testified was his practice, and there's no evidence that he didn't, he's sold 3,000 policies and nobody else has ever complained, he's never been cited for this. Mr. Jervis testified that if Mr. Mercurio had told him what Mr. Mercurio said he told everyone, that Mr. Jervis would have understood. Mr. Jervis received the coverage binder the day before the policy issued within minutes of the call, and he testified to that at transcript 2021, page 2021, Defense Exhibit 5, which was admitted without objection. That verification showed that he had and in what limits it was provided. And Mr. Mercurio testified, even in response to a question from the jury, that that form showed that the coverage was non-stacked. And finally, part of why Mr. Jervis went to Geico after being with State Farm for so many years was to save money. Mr. Mercurio testified that stacked would have cost about twice as much as non-stacked. Mr. Jervis saved money. All of that evidence was what the jury heard, and what the jury was instructed was, do you find? And I read the instruction to you, which is at record 8355. And the verdict form is consistent at 8364. Did Mr. Jervis make a knowing oral selection of non-stacked uninsured motorist coverage or a knowing oral rejection of stacked before the Geico policy was delivered?
Let's assume this isn't just the stacked. Let's go to 1. Is your argument the same, that it's oral, if they don't get the standard form from the from the insured that's approved by the department, that it doesn't matter because they can go in and put their general business practice on and explain how over the phone that they've checked these boxes and that's good enough?
Well, that's not what happened here, because we have an application that was prepared contemporaneously and a verification form that was provided to the insured immediately.
Because it was over the phone, nothing was signed by Mr. Jervis.
The form that only the trial judge saw.
What I'm asking is, your argument with respect to you don't have to give the written notice in the form approved by the department would apply both to 1 and a 9.
If we were in a 1 case, which we're not, because coverage was purchased here, there's no issue as to rejection of
But the question is the form, and what you've said is you don't need the form. You can go in and you can prove your case based upon oral statements, and the form is of no use. I mean, you don't even have to introduce it into evidence.
That is absolutely correct, Your Honor. That is our position as a matter of law, and our position on the record.
Let me see if I understand it. So, because I was always under the impression that under Section 1, you had to have an insured named the policy must make a written rejection of the coverage on behalf of all insureds under the policy, 627, 727, 1.
So that would be if you weren't going to have any coverage at all.
Okay. So
And here, there's
so
no
on the-
issue.
No, I get it. I just want to understand the whole framework from your position. So whether you get a or not, you concede that's written. But whether or not you have stacked or not, your position is that would be, if you want a presumption, then you would have it written. If you don't have a presumption, and then it becomes a jury question on 9.
That is correct with respect to 9. I respectfully submit to Your Honor that the cases under 1, such as Chmielewski and Quirk, hold that even without the form, the same protocol is
That's the whole
appropriate.
point. I think
But that's
I-
one, and
I
we don't
think
care about one because we're not necessarily,
Your analysis for 1 would be the same as 9.
it would if we had a one case, but we don't.
But other than
And-
Cabrera and Muhammad, I mean, which case involves a situation where there was no form?
Belmont,
Belmont, the court says in footnote 1 that the form at issue was the one approved by the department.
well, it was, but the insurer was not allowed to rely on it because the policy said, the statute provides that if you make your, whatever selection you make will hold through renewals. Allstate's policy form in Belmont said, if this will apply to renewals consistent with the statute unless you change your BI limits. So Allstate had a unique provision in its policy. In Belmont, the insureds changed their BI limits after having made the selection, the rejection of UM. So their argument was that form doesn't bind and it's no good, same as here, different reason, but same outcome, form not applicable. And the court said that's correct. Because of Allstate's policy language, and this is what Belmont says, because of Allstate's policy language, the form didn't hold to renewals. So the Belmonts were traveling on a renewal that the Allstate did not have the benefit of the form, just as Geico here, for a different reason, but same legal problem, form defective, not usable. Belmont controlled here. The trial judge followed it, so did Cabrera with respect to jury instructions. There was no error. The trial judge didn't abuse his discretion, and we respectfully request that this court affirm. If there are any other questions, I'd like to answer them. Thank you.
Thank you. You can have 1 minute.
Thank you very much.
Thank you, Your Honor. Good morning. I have 60 seconds. I'm going to move very quickly. I wanted to answer Your Honor's question.
State your name for the record. So
Sure. Jeff Stahl, on behalf of the Jervises. Judge Crows, you asked about the Belmont case. I know that you picked out the footnote 1, but in the Belmont case, it was different cars that changed under the policy. So in Belmont, you ended up with a situation where there was the absence of a written rejection form. In this case, and this appeal is entirely about what happens in a legal perspective when there's the absence of the statutorily mandated written rejection form. For the named insured, a not code tells us from the 3rd District Court of Appeal that the named insured gets full coverage by operation of law. The same 3rd District in Cabrera said in the Class 2 context where we had trucking employees who were making a claim for benefits under the employer's policy that you don't stop at the absence of a written rejection. Instead, the insurer can attempt to show that there was an oral waiver of the statutory right to the written rejection. If you look at Quirk, if you look at Ledford, if you look at all these Class 2 cases, and Belmont was Belmont's daughter, the policies talk about a household family being Class 2 insureds, but in any context, a Class 1 insured or a Class 2 insured, the question is whether the insured was given notice of their statutory right to a written rejection. So when Your Honor asked, how come there was no mention of the statute? We repeatedly tried over and over and over, and the trial court never allowed any discussion, any proffer, any information to the jury that this heavily regulated body of insurance law existed and that this mandatory form was required. Again, Class 1, 3rd DCA and not Cove, named insured gets it by operation of law. Class 2, Cabrera, same 3rd DCA, you don't get it by operation of law, but Class 2 can go in and try to show, and the insurance company can try to show that they got an oral waiver of the statutory right to a written rejection.
Okay.
Here, nothing about a written rejection.
thank you.
Thank you.
Thank you both. The next case is Strong.